So let's go ahead and get started. So I'm really excited to announce our speaker today, Andrew Leroy Rudder, an owner and founder of Rudder Law Group. I had the special opportunity to get to know Andrew last year at ClioCon, where we were able to do a session together, and I can't think of a better topic for him to speak on. Andrew is also one of our Reisman Award winners from 2022. And if you're not familiar with the Reisman Awards, it's a very special award that we give out to a really select few group of people for the amazing work that they're doing with their clients and within their community. So without further delay, I'm going to turn it over to Andrew to take it away.
Thank you so much, Mackenzie, for that introduction, and welcome everyone for joining us today. To get things started, I thought it would be good to begin with a poll question. So, Jocelyn, if we could launch that poll. If not, then maybe we could get up. There we go. So the question is, what do you think is a top client complaint about their lawyer? And you see you got 6 options there. So if you guys could begin voting right now, that would be awesome. So we got the votes coming in, and the vast majority of you, very smart audience, you looked at the topic that we are discussing, and obviously, yes, you are correct. It is a lack of communication. So anecdotally, when I ask lawyers this question, they rarely say lack of communication. But the American Bar Association says that the most common disciplinary complaint filed against lawyers is a lack of communication. If you think about it, a lack of communication is connected to some of the other top 5 complaints. For example, the complaint of misrepresentation and dishonesty is a lack of honest communication. The complaint of scope of representation is a lack of clear communication. But if what some lawyers think is a top complaint from clients is different from what clients actually have stated is their top complaint, then this is a potential sign of a problem of a lack of effective communication and mutual understanding between lawyers and clients. Also in Ontario, Canada, where I practice, the lawyer's professional indemnity company, LawPro, which provides liability insurance, stated, quote, in almost every area of practice, the #1 cause of claims to LawPro is a breakdown in lawyer-client communication, end quote. This is oftentimes due to a combination of lawyers being busier than they ever were, and clients in the age of Amazon and Uber expecting fast replies and round-the-clock responses from their lawyer. People don't always remember everything you said or did, but they do remember how their experience with you made them feel. Whether you're having an intake meeting with a prospective client, emailing prep materials, texting an update, calling to deliver bad news, or meeting in person, you shape your client's idea of what it's like to work with your law firm every time you communicate with them at every stage of the litigation process. Your client's opinion, positive or negative, will ultimately come from their overall experience from all of the various communications with them, which can mean the difference between an old client referring you to someone else and writing a glowing Google review, or speaking bad about you and writing a mediocre or scathing review. So it's important to take a holistic approach to formulating the underlying philosophy that guides you in all of your client communications. You want to create momentum of positive experiences that add up throughout your client's journey from the beginning all the way to the end. One of the key elements of any effective client communication philosophy is a focus on empathy. It's also at the heart of a client-centered law firm. So today I want to talk about the importance of empathy and how it empowers us to better understand our clients and help them navigate through the unfamiliarity of the personal injury litigation process. I want to discuss a few aspects of client communication at some of the early stages of the litigation process, beginning with the pre-retainer and retainer stage. At the gathering facts and document stage, I'll introduce the concept of tactical empathy, which is one step beyond empathy, as well as the power of active listening. I'll show you how tactical empathy can be strategically used to de-escalate angry confrontations of clients and guide them to arrive at a solution on their own, which is aligned with our goals. I'll do that by spending a lot of time practically applying tactical empathy to an actual fact scenario that's loosely based on one of my client interactions. That's my goal, but if I have time, I'll briefly discuss client communication at the deposition or examination for discovery stage, the settlement stage, the trial stage, the completion stage, and the post-completion stage. And if I don't have time, don't worry. I prepared a detailed 44-page paper for you guys to review, which I hope you've downloaded. So in our personal injury law practices, many of our clients are coming to us in their darkest hour, where they have no hope and they have an uncertainty about their future. They are looking for a lawyer who understands both legally and personally all aspects of the devastation caused when someone falls victim to a personal injury. The situation that our clients find themselves in following an accident is a precarious one. Empathy is trying to understand the situation following a devastating accident from our client's unique perspective. Generally speaking, it's the ability to recognize the perspectives of our clients and then vocalize that recognition to them. Empathy involves the following three things. One, making a commitment to understanding your client's world, both pre and post accident. Actively recognizing the unique perspective of our clients by paying close attention and actively listening to them. And vocalizing that recognition of our client's unique situation and perspective to them, so they feel that they were listened to and know that they were heard and understood. Empathy is different from sympathy which is more akin to agreeing with your client's values and beliefs. Empathy is not merely a soft communication skill, as it also has a physical basis. Researchers at Princeton University conducted a brain scan experiment where they applied a functional MRI to record brain activity from both speakers and listeners during natural verbal communication. When the listener closely observed the speaker's tone of voice, gestures, and facial expressions, the listener's brain activity began to mirror the speaker's brain activity. Their brains became more aligned in a process called neural resonance or neural coupling. What's just as remarkable is the active listener was also able to better anticipate what the speaker was about to say and know more fully what the speaker was thinking and feeling. I want to start by discussing the pre-retainer stage, primarily to highlight how empathy plays an important role, because it's here where you're identifying who your target clients are. Successful advertising and marketing campaigns involve first taking a deep dive into really knowing your prospective clients in order to tailor your marketing message directly to them and really resonate with them. You're not merely trying to know your target audience on a surface level, like there are people who are injured in a motor vehicle accident. Rather, successful ad campaigns need to know your prospective clients on a much deeper, substantive level, such as their deepest and most primal desires, their fears, hopes, wishes, and dreams, how they think, what they're thinking about, but not telling anyone, so they could enter into the conversations they're already having in their minds. So the more empathy helps the marketing message resonate with prospective clients, the greater is the likelihood that they will contact you for a free consultation. I want to now highlight some things to keep in mind while marketing at the pre-retainer stage. Make sure you're aware of the rules of professional conduct in your state or province where you practice, which set out the requirements for communication in the marketing of legal services. They're intended to ensure that your marketing does not mislead by failing to make clear what services are actually available and are intended to be provided. I'm from Toronto, and one of the examples of marketing that may contravene Ontario's rules of professional conduct is the following, quote, stating the amount of money that you have recovered for a client or referring to your degree of success in past cases, unless the statement is accompanied by a further statement that past results are not necessarily indicative of future results, and that the amount recovered in other litigation outcomes will vary according to the facts in individual cases, end quote. This was important because I see lawyers in my province promoting the amount of money that they obtained in their biggest settlements, but forget to include that disclaimer. I think it goes without saying that you should avoid misleading and deceptive marketing practices. It might get the client to sign the retainer, short-term gain, but when your clients learn that you misled them, you lose their trust and respect. And depending on the degree of deception, it may negatively impact their experience of working with your law firm and influence how they talk about you to others. More importantly, misleading and deceptive practices tarnish your reputation, long-term pain. Also, be careful about over-promising results just to win a new client's business. I prefer to under-promise and over-deliver. Clients appreciate honesty and a realistic vision of what they can expect if they move forward with you on their legal matter. Plus, you engender trust more trust rather, when you consistently do what you say you're going to do. Manage expectations as early as possible by being transparent and intentionally setting the stage for the parameters surrounding the communications you want to have with your clients. For example, I outline the scope of my legal services in my written letter of engagement, including the parameters surrounding communications. I specify generally what the communications will entail, example, progress reports and updates, how often my clients can expect communications from me. I send out progress reports at each major stage of the litigation process. How soon I will respond to my clients. I endeavor to respond within 24 hours, no later than 48 hours. Which communication channels I'll use. I personalize it to my client's personal preference. I choose to make myself available to my clients outside of regular 9 to 5 work hours during the weekday, as well as the weekends, which I state in my engagement letter. However, many of my PI lawyer friends think I'm crazy and are uncomfortable with that. And that's perfectly fine, as long as they outline more confined and restrictive parameters regarding communication so their clients know upfront what to expect, so there are no surprises. I also use the engagement letter and the retainer agreement to clearly define our goals or what we hope to accomplish. And you'll see one of the reasons why I do this when I take you through the fact scenario later in my presentation. For example, I include things such as the following. You hope to obtain a fair and reasonable amount of money for your injuries that compensates you for your pain and suffering, loss of wages, and your medical, drug, and other out-of-pocket expenses. Our clients have expectations, but don't forget that we have expectations of our client as well. If those expectations are met, it'll enable us to have the best chance to meet our predefined goals. So I communicate to my clients that the legal relationship is cooperative, which means that it involves mutual assistance in working together. For example, I also include in the engagement letter something like the following. You understand that you need to seek the recommended medical treatment in order to mitigate your losses and assist you with reaching maximum medical recovery. You understand the importance of giving us all the facts and of being totally honest with us. In particular, we ask you to give us all information you have or have access to, which could help us in working on your lawsuit. We need copies of all letters and documents relating to the accident, medical reports, physiotherapy records, tax records, paycheck stubs, and medical, drug, and parking receipts. I also send them a document created by my law society that explains in plain language what a contingency fee agreement is. The client intake process is the first experience your prospective clients have communicating and working with you. This will ultimately set the stage for what is to come if they sign the retainer agreement. You only get one chance to make a good first impression. So make sure that their first experience is smooth and a memorable one, which will enable you to build momentum. Also, as a solo practitioner myself with limited resources, I expedite a smooth intake process by using client relationship management software. I use Clio Grow, which enables me to automate a lot of the administrative tasks associated with the intake process. But of course, there are other options than just Clio. I like Clio Grow because it allows me to create my own custom checklist templates, which identifies the steps I need to complete and the deadlines to do it in. I can also create custom automated email campaign templates, which assist with guiding my clients through those steps toward becoming ultimately a retained client. Remember, the smoother the intake process is, the better the first experience is ultimately going to be. And here, if you guys could just click yes over here, yep, just to verify that you are participating.
Thank you. Yeah, that's our CLE poll, so please respond. And then, Andrew, you can keep going and we'll just keep this up for a couple more seconds for everyone else.
Okay, perfect. So now I want to talk about the retainer agreement stage, where it's important to set the tone early to distinguish yourself. Just like how some of us visit the car collision scene to learn more about the accident dynamics, well, I also visit my client's home to learn more about the family dynamics. Prior to being retained, many of my clients had told me that the insurance adjuster that they spoke with came across as distant and cold as opposed to soothing, which made them feel like they were being treated like a claim number as opposed to a person. When I show up at my client's house and meet their immediate family, I communicate them through my actions that they are much more than just a claim number and they are worth my time. I also communicate to my client's support system, their family, that I care about their loved one and I'm different. When we get to know the family who are impacted by our client's impairments, they also give us valuable information and insight into their impairments and the unique challenges they face in the home and surrounding environments which you wouldn't have otherwise learned. The more we learn about the full extent of our clients' impairments, the better we can advocate for them. In addition to seeking updates from my client, I also inform and update my clients clearly and provide them progress reports at the major milestones of the litigation process. I do so further to my engagement letter and my retainer agreement where I outline the scope of my communication with my clients. My clients love it because I do what I said I'll do, which engenders more trust. Plus, they're kept in the loop and are able to make informed decisions. I said earlier that I make myself available to my clients outside of normal business hours, which I know sounds crazy. Well, my clients rarely call me outside of regular work hours when I update them on a consistent basis. Updating your clients regularly may seem like a time-consuming task, but it's not when you realize that the milestones in the litigation process of a personal injury lawsuit are pretty predictable. Since the goal at each major milestone of litigation is similar for all my clients, it makes it easier to create templates for the progress reports and update letters I send out. Of course, I alter the template slightly to factor in specific details that are unique to a particular client's case. Good advanced document management software makes periodically updating your clients even easier. For example, I use Clio manage rather, and its personal injury add-on component. And again, there are other legal software solutions available. One of the cool features I like is called matter stages, which are kind of Kanban style boards that I use much like a pipeline to visual and track the progress of my clients' cases through the predictable stages of the litigation. It allows me to create task list templates, which are a series of pre-built administrative tasks which directly correspond with the 10 stages of the litigation process. So in regards to updating my clients, one of the tasks I create in each stage is to send out a progress report to my clients. Clio Manage also allows me to create document templates, which again, I organize by the 10 stages I identify. Some of my document templates are, you guessed it, the progress reports that I alter a bit and send out at each stage of the major milestones of the litigation process. Updating clients is not just good client communication, but it also ensures that you stay compliant with your rules of professional conduct and ethics. As lawyers, we have a duty to communicate case updates rather to our clients promptly. In the province of Ontario, where I practice, we have a rule of the rules of professional conduct, which describes a competent lawyer as one who, quote, has and applies relevant knowledge, skills, and attributes in a manner appropriate to each matter undertaken on behalf of a client, including communication at all relevant stages of a matter in a timely and effective manner. Using legal software to communicate more efficiently with our clients is great. However, since we're required to keep our clients' information confidential, just remember to exercise due diligence regarding any technology tools you use. Ensure that your communication channels are secure and encrypted. For example, I know Clio applies both in transit and at rest encryption using industry best practices to ensure my clients' confidential data is safe and being transmitted securely. This gives me a lot of peace of mind. Also, keep track of the standards set by your law society or your state bar association for keeping client information confidential. Earlier, I highlighted how some of the automated features I use in Clio Grow and Clio Manage are great. Well, sometimes in-person communication is preferred over automated communication. So for example, pretty much all of my teenage clients express a preference for receiving correspondence via text messaging. They wouldn't have it any other way. I respect and try to honor their personal preference, but I still have to exercise my discretion. For example, simple and transactional communication, such as a new client welcome, that's fine to automate. And a quick confirmation message, such as, I got your note, thanks, is fine to send out via text message. However, more personal and specific communications are best left to humans, such as a client who is upset and looking for reassurance, an important update regarding a major new development in the case, or as we'll soon find out in my fact scenario, a difficult conversation of clients who hit a rough path and are angry and uncooperative in a manner that is detrimental to their case. Now I want to shift focus to the gathering facts and document stage. So earlier we discussed empathy. Well, one step beyond empathy is tactical empathy. So I first learned about this concept from Chris Voss, who was a former FBI hostage negotiator. He is now one of the preeminent practitioners and professors of negotiation skills in the world. He was one of the keynote speakers last year at ClioCon 2023 in Nashville, Tennessee, where I also had the opportunity to speak at. I was fascinated when I heard him speak about this concept. So I read his book, Never Split the Difference, in order to learn more about it. I then started to practically apply it to my communications of clients who in particular were diagnosed with mental and behavioral disorders under the DSM-5, and who at times struggled to control their mood swings and acted out in ways that didn't help their case. So tactical empathy is first understanding the mindset and the underlying feelings that motivate your client's surface level presenting behavior. It also involves hearing what is behind your client's feelings so you increase your influence in all the moments that follow. It brings your attention to both the emotional obstacles that you have to figuratively knock down, while at the same time discover the potential pathways to guide your clients to realize on their own the solution you want them to arrive at, which mirrors the general goal you originally wanted to achieve for them. So as Chris Voss has stated in his book, tactile empathy is emotional intelligence on steroids. So now I'm going to delve deeper into tactical empathy by actually applying it to a similar fact scenario I recently had to deal with in one of my cases. Some of the tactical communication techniques that I'll explore while engaging in active listening are mirroring, asking calibrated how and what questions, labeling, using effective pauses, using minimal encouragers, paraphrasing, and summarizing. I'll first show you how I use them to probe, example, identifying clients' underlying feelings. I'll then show you how I use them to guiding clients to find solutions on their own. So here's a fact scenario. My client, who I'll call Jay, he was involved in a devastating car accident where his vehicle was hit by an 18-wheeler truck. He sustained severe physical, psychological, and cognitive impairments, and he just demonstrated significant challenges of chronic pain, mental behavior disorders, and cognitive functioning. He was in dire need of a lot of treatment so he could reach maximum medical recovery. We needed supportive medical evidence to bolster his case as well. I got the insurance company to pay for psychological sessions with a psychologist and $3,000 per month for attended care services provided by a personal support worker, PSW, at his house. So what was the problem? Well, the occupational therapist I brought on board told me that Jay was refusing to allow PSW into his house. The psych clinic told me that Jay was rude to their staff and was refusing to attend psychological sessions. What should I do? My client is uncooperative and rude to the people I brought on board to help. Jay prefers correspondence via text messages, but I decided an in-person meeting was appropriate. However, due to his mobility issues, I opted for a video conference. I sent him a text message via Clio managed to arrange it, and he accepted it. Prior to my video conference with Jay, I first identified the goals of the meeting. My goals were to get Jay to start attending psych sessions, respect the staff at the psych clinic, and allow PSW into his house. I discussed these three goals with the OT, which made it harder to wimp out. But more importantly, I did it to obtain a different perspective and to make sure I had a clear understanding of the situation. I also wrote it down on a piece of paper so I could remind myself the goal as we go deeper into the conversation. The other important thing I keep in mind is most people's emotions have two levels. The first level of emotion is a surface level emotion or the presenting behavior that you can immediately see and hear. The second level of emotion is the beneath the surface level of emotion, which are the underlying feelings that you can't see that motivates the presenting behavior. So in my case, Jay's surface level emotion was anger, and I had to figure out what his underlying emotion was, which was causing him to act out against the staff at the psych clinic, refuse psych treatment, and not allow a PSW in his house. If I don't, then his underlying emotion is going to function like an emotional barrier, which will prevent me from helping Jay. So I use tactical empathy. My three primary objectives of tactical empathy are: one, engage in active listening in a probing manner in order to identify Jay's underlying feelings that's motivating his presenting behavior. Two, use active listening to make him feel listened to and understood in order to drain out the emotional anger from his dialogue and knock down the emotional barrier that's blinding his rational judgment. And three, use active listening in a guiding manner in order to guide Jay toward discovering on his own volition the solution that mirrors our original goal to help him. One of the important things I tell myself going into the conversation of Jay is listen with the goal of understanding. Too often we listen to speak to show how wise and intelligent we are as lawyers. Other things to also keep in mind are: be open-minded and do not make assumptions. Be non-accusatory and reserve judgment. Don't demand or pressure Jay to just do what I say, because if he complies, he's not going to be committed to following through on it. And don't interrupt other than to show Jay that I'm listening. I first want to highlight what's known as a 738-55% rule, which indicates that only 7% of all communication is done through verbal communication, the words we speak. 38% from the nonverbal component of our daily communication, such as the tonality of our voice, and 55% from the speaker's body language and facial expressions. So during active listening of Jay, I pay close attention to not just his words, but especially his tone of voice and body language. I asked Jay, "How are you feeling?" He replied, "I'm doing fine," words. But in regards to his tonality, he sounded emotionally spent. In regards to his body language, he was slumped over in a dejected posture, and he was looking down at the floor to avoid eye contact. I saw an incongruence between Jay's words, "I'm doing fine," and his nonverbal signs, which obviously revealed to me that he was not fine. Now, this seems basic, as it's one of the more intuitive aspects of active listening, but doing this is one of the first signs that you're dialed in, focused on understanding your client and establishing that neural resonance that I mentioned earlier with your client. It's also a reason I opted for a video conference. Effective pauses in active listening is also valuable. After Jay replied, "I'm doing fine," I knew he wasn't, and he had more to say, so I patiently waited for him to say it. Silence is powerful. Most people are uncomfortable with silent periods in a conversation and rush to break the silence too soon. Learn to sometimes embrace silence in situations like this, when you know your clients want to say more, but are gathering their thoughts. I use an effective pause for emphasis and to encourage Jay to keep talking until eventually he does. I also use an effective pause to let him recognize and appreciate my initial attempt to understand what he's feeling. Mirroring. After I embraced silence, Jay said very angrily, "I'm not going to psychotherapy." I mirrored what he said and replied with an upward inflection. "Not going to psychotherapy?" Jay replied, "Yes." And then he said, "I'm not allowing a PSW in my house." I mirrored him again. "Not allowing a PSW in your house?" with an upward inflection. Rather than argue with Jay at this stage, I remained cool, calm, and collected, and listen and repeat back what he is saying. Why? An idea sometimes sounds great within the confines of your own mind, but as soon as you say it out loud a couple times, you start to assess it a little differently, and suddenly it doesn't sound so clear-cut. After Jay assessed his adamant stance more closely, he yelled, "This accident effed up my life." At this stage, I begin to employ tactical empathy by using what is known as labeling, where I recognize and verbalize Jay's emotions in the situation. It puts myself in Jay's shoes. It enables me to spot Jay's feelings, turn them into words, and then very calmly and respectfully repeat his emotions back to him. I do so by saying, "Your motor vehicle accident seems so tragically unfair. I can see why you sound so angry." By labeling Jay's anger, I'm validating his emotions by acknowledging it. By giving Jay's emotion a name, anger, I show him that I identify with how he feels. It gets me closer to him without asking about external factors that I know nothing about at the moment. It's kind of a shortcut to intimacy or time-saving emotional hack. Labeling typically starts with words like, it seems like, it sounds like, it looks like. Labeling is especially advantageous in the case with Jay, who is tense, because by exposing his negative thoughts to daylight, it makes them seem less frightening. Labeling negatives like the emotion of anger diffuses them or defuses them in extreme cases. So it's a helpful tactic in de-escalating angry confrontations with your clients because it makes them acknowledge their feelings rather than continuing to act them out. After I labeled Jay's negative emotion, he replied, "That's right. I hate that I'm so angry." It's important to note here that I'm not necessarily searching for, yes, that's right. Hearing no, that's wrong is also useful because if Jay corrects me, then I get more information, which I need to better understand him and guide him in the right direction. I would then simply calibrate my next label accordingly or ask a question to get his help to correctly identify the feeling. I now want to move past Jay's surface level of emotions. I want to dig deeper to identify his beneath the surface level of emotions or underlying feelings that's motivating his current behavior and creating this emotional barrier. So I do this by asking Jay a series of calibrated what and how questions, which encourage cooperation, as opposed to why questions that could sound accusatory unless delivered with the correct tone. As your clients are speaking to you, if you ask them questions, they'll know that you're hearing them and that you're asking for more information to better understand them. I asked, what's the biggest challenge you face right now? Financial difficulties. I'm drowning in bills. I'm not working. What's the core issue here? My wife is questioning my manhood. I can't provide for my family. I feel like half the man I used to be. I'm doubting my own manhood. How does that affect things? I question my self-worth. I can't sleep at night. I wake up at 11:30 a.m. in the morning. I know I need help, but I can't focus right now on taking calls or seeking treatment. Then further to our initial meeting at his house, where I set the stage, I reminded him what our goals were by asking, what are we trying to accomplish with our lawsuit? Jay replied by paraphrasing the goals we set out in the engagement letter when he said, get the treatment I need to get better, reach maximum medical recovery, reintegrate me back into life, society, and work, get me to just compensation I deserve. When I'm actively listening to my clients, I also use what's known as minimal encouragers. As Jay was answering my probing how and what questions, I use simple phrases such as yes, okay, or I see. They effectively convey to him that I'm paying full attention to what he's saying. After your clients finish telling you about their situation, summarize it. You're not parroting them or repeating what they said verbatim. Summarizing is a combination of paraphrasing and labeling. So a good summary is a combination of re-articulating the meaning of what your client said, paraphrasing, plus the acknowledgement of the emotions underlying that meaning, labeling. You first paraphrase the salient points by repeating to your clients what they said back to them in their own words. This powerfully shows them that you really understood them and aren't merely parroting their concerns. If you do this right, then the only possible response from your clients would be something equivalent to what Chris Voss says is that's right, which is an indicator that they know you understood them. When they say that's right or something similar, they feel that they have assessed what you said and pronounced it as correct of their own free will. They embrace it. I said, it seems like your family is valuable to you. You love your wife so much that her words hurt. That's right. It seems like you value being the breadwinner of your family. It hurts you not being able to be the man who can provide for your wife and daughter. You got it, sir. Your bills are rising so high that you can't focus your mind on anything else at the moment. It looks like having some money in the short term may make it easier until I'm able to settle your file. That would work. It sounds like you know you need help, but you're reluctant to receive it because of your dire financial situation and stress. Jay nodded his head. That's right. I'm not only identifying how Jay feels, but I'm also communicating to him that I've been listening to him. So now that I've identified Jay's beneath the surface level of emotion that's motivating his presenting behavior, which was his feeling of vulnerability and helplessness rooted in his dire financial situation and accident-related impairments, and his inability to be the man he once was who can provide for his family, Jay felt listened to and understood. So his defenses were slowly coming down, and he was now more receptive to some suggestions. Dale Carnegie has a great analogy in his book, How to Find Friends and Influence People. Imagine that there's an empty bottle that fills with water every time your clients talk about a situation like this. Before the bottle is full, your clients feel unheard. Every time you interrupt your clients, you figuratively empty the bottle and your clients have to start again. However, once the bottle is filled, your clients become more receptive to new thoughts and suggestions. So now Jay's in the right mental headspace to receive suggestions that address his specific issues he raised. Remember, good listening isn't always associated with jumping in and solving a problem, but when delivered well, suggestions can be a good sign of a good listener. However, your delivery and the tone you use is of the utmost importance. In this case with Jay, I suggested options to him to address his dire financial situation. So I introduced him to a company that offers personal injury settlement loans and litigation lawsuit loans at a low rate, which in this case was Bridgepoint Financial. After identifying my clients beneath the surface level of emotions, my objective changes from probing to guiding. In Jay's case, I began guiding him by using the same tactical communication techniques we had previously discussed. The goal is now to let Jay feel that the solution he arrives at is his own. Why? Well, most people like their own ideas better than other people's ideas. Coming up with our own ideas makes us feel smart and important. Executing our own ideas instead of someone else's gives us a feeling of control. Since Jay will believe that he gave the solution to a specific problem, he will be much more engaged and interested in implementing it successfully. This approach is also discussed in Chapter 9 of Dale Carnegie's book, How to Win Friends and Influence People. So I asked, what other options do you have to help you get by financially and get through this difficult situation until I'm able to settle your file? Silence. No problem. I used another effective pause. He replies, I don't know. I continued to ask, what other sources of revenue do you have? A light seemingly went off in Jay's head, and he answered, I have an inheritance. I asked, what impact did this inheritance have on your ability to deal with your current financial situation? It would help a lot. How soon can you access the inheritance? In a few weeks. I need 2 other people to sign. What can we do in the next couple of days to expedite the release of the inheritance? I can call the lawyers. I can talk to the other family members. Will you do this? This is important because I wanted him to commit to it and say it out loud so someone else hears it and can hold him accountable. Yes, I will do this tomorrow. I didn't set a task reminder and Clio managed to follow up with him. Finally, I asked, how does this fit into what our objective is? It'll help me to cover my bills during the interim, keep my head above water, and allow me to focus on getting the help I need to get better and mitigate my losses, which, if you remember, was one of the expectations I had of him that I set out in the initial engagement letter. Bingo. Jay arrived at a solution. I just guided him with calibrated how and what questions. Next, I used suggestions to further support the conclusion that he arrived at. I first asked, how long can you get by with your savings? He replied, 3 more weeks. I then suggested, let's see if you get the inheritance in the next 2 weeks. If you don't, then we can proceed with the loan from Bridgepoint Financial. What I'm also doing here is showing Jay that I'm cooperating with him, in addition to supporting the idea that he arrived at. At the beginning of our video conference, Jay was skeptical and cold. However, as soon as I demonstrated to him that I recognize his feelings, fears, passions, hopes, dreams, using summary effectively, the walls came tumbling down. The moment you've convinced your client that you truly understand their feelings, mental and behavioral change becomes possible, and the foundation for a breakthrough in overcoming their emotional barriers has been securely laid. There is nothing more frustrating or disruptive to any communication, whether it be with your client, opposing counsel, or significant others, then when you get the feeling you're talking to someone who isn't listening, who's simply waiting for their opportunity to speak, and doesn't try to understand your position or point of view. If I had ignored Jay's unique situation and wasn't committed to listening to him, what do you think would have happened? I would have only built up frustration and made him less likely to do what I wanted him to do. Now that the financial issue, the biggest challenge, and the emotional barrier were gone, I can now address the issue of psychological treatment with the same tactical communication techniques. But first, I have to acknowledge that it takes courage to discuss your underlying emotions with someone. We keep our beneath the surface level emotions hidden for a reason. After a client reveals them to me, they feel vulnerable in the moment. So before I continue to guide Jay in the right direction, I first made him feel supported, not criticized. And then I'm cooperating with him. I said, it's not easy, man, putting your life back together after a devastating motor vehicle accident. He didn't respond, another effective pause. When I realized he had nothing else to say, I said, I want you to know that I've got your back. We're going to get through this together. He replied, thank you, sir. I appreciate that. Then I began to use paraphrasing and labeling to further guide him to the right solution to attending psychotherapy. I said, it sounds like you want to get better and work on getting as close as possible to the man you once were before the accident. I do. I then used labeling to highlight out loud his psych issue. It seems like you have ongoing psych issues from the NVA. That's right. Then I asked Jay a calibrated how question to allow him to arrive at the solution himself. How can we address your psych issues and set you on the right path to recovery? I need to get treatment for my psych issues. Then I used summarizing to guide him to finding a solution with treating the staff at the psych clinic with respect. I said, it seems like you sleep in a lot because you're up all night worrying about your future. That's right. You wake up at 11:30 a.m. and feel grumpy in the morning, which is the time that the staff from the psych clinic call you. Yes, sir. That's right. How can we ensure that you meet with the staff and book the appointment and get the psychological treatment you need? We can book the appointments in the afternoon, sir. I'm in a better mood in the mid-afternoon, so I won't be so grumpy with the staff. Again, I guided him toward arriving at a solution to put him in a better mood to communicate with the staff, the psych clinic, with respect. More importantly, he arrived at one of the many possible solutions on his own that fits his specific needs, so he'll be more committed to it. Plus, the solution mirrors the general goal I originally wanted to achieve for him. I then addressed the problem of the PSW not being allowed into the house. I started by saying something like, with so much going on, such as your financial stresses, which consumes your focus, plus your ongoing pain, it sounds like you can use some help around the house. That's right. I said, it seems like you're open to receiving help from a PSW. I could really use the help. I got Jay to acknowledge out loud that he needs the help, but he still didn't commit to it. Why? Jay didn't commit to allowing the PSW into the house because there still was what Chris Voss calls a behind-the-table deal killer, which I needed to identify. So I needed to figure out if there were any other people who could hinder Jay's ability to proceed. Since I invested time early in the case to visit Jay's home and meet his family, I was fully aware of the family dynamic, which helped me identify who the person might be. I then used calibrated how and what questions to identify the deal killers. I asked, how on board is your wife with bringing a PSW into the house? No response, effective pause. Then he answered, she's not on board, but didn't elaborate, effective pause. My wife works from home and requires privacy throughout the day. Her office is in the living room. Got it. That is the barrier. That is the deal killer. I asked, what's the biggest challenge we face? He replied, figuring out how to get the PSW in my house without disturbing my wife. Jay was so blind with anger that he didn't see the solution, which was in plain sight. I just diffused the anger and guided him toward the obvious answer. I then said, since you wake up late, it seems like you prefer to receive treatment in the afternoon. That's right. I then unearthed the deal-killing issue with calibrated how and what questions in combination with guiding suggestions. I asked, what time does your wife finish work in the afternoon? Jay replied, 3:45 p.m. I made a suggestion. Our PSWs work until 5:30 p.m. I then use an effective pause to let his brain process this new fact. I then asked, how can we ensure you get a PSW to help you in person at your house without interrupting your wife? The PSW could come at 4 p.m. and stay for 60 to 90 minutes. I concluded by suggesting I know a company that also offers virtual PSW and OT services. He pondered a suggestion and then stated, I can receive the virtual services for an hour until 3:45 p.m. and an in-person PSW services at 4 p.m. You can see how I'm asking questions instead of giving orders. Why? Instead of following someone's orders, Jay is following his own. It also stimulates Jay's creativity because, as you can see, a new and better solution combining virtual and in-person PSW services came up, which is specific to his unique situation. There are 100 different possible solutions here that would correspond with our general goal. I need Jay to find on his own the one solution that works for him. So in conclusion, when you're dealing with uncooperative clients, especially ones diagnosed with mental and behavioral disorders you want to help, then try employing the use of tactical empathy and active listening to first understand their mindset and the underlying feelings that motivates their surface level presenting behavior. By doing this, you'll bring your attention to the emotional obstacles that you have to figuratively knock down, while at the same time discover the potential pathways to guide them to realize on their own the solution you want them to arrive at, which mirrors the goal you originally wanted to achieve for them. So let's take a look or talk about rather communication at the deposition from my American friends and examination for discovery from our Canadian friends. Good client communication is also about being proactive and preemptive so that our clients feel truly informed and cared for. So I do this by anticipating what frequently asked questions they will have about a particular major milestone in the litigation process and answering most of those questions before they ask them. So for example, at the deposition stage where via empathy, I know my client's anxiety levels are through the roof from the fear of this unknown, unfamiliar situation and the prospect of being asked questions from opposing counsel for several hours about something that happened a while ago. I send my clients a letter to answer some frequently asked questions in order to give them an overview of the process. I also send my clients a detailed guide on how to answer the kind of questions that they will encounter, and I simplify it by categorizing those questions in 3 different areas. When my clients read the letter and the guide carefully, their anxiety levels decrease substantially because the shroud of mystery for the process is unveiled and many of their questions are answered. So now at our prep meeting, we spend more time concentrating on the merits of their case as opposed to explaining the basics. Also, after client calls or meetings, I like to be proactive by sending an email or text message to my clients, which summarizes what was discussed and sometimes provides supplemental information for any next steps that have to be completed. At the private mediation or settlement conference stage, I want to bring to your attention a psychological concept called anchoring. In order to better understand anchoring and its influential power over people and communication, consider this example from Kevin Dutton's book called Split Second Persuasion. I finished reading it recently, great book. Ask 2 friends this question. How many gallons of diesel does it take to fill up a jumbo jet? Ask the first friend this follow-up question. Is it more or less than 132 gallons? Ask the second friend this slightly different follow-up question. Is it more or less than 132,000 gallons? Now ask both of them in turn to come up with a concrete estimate of just how many gallons of diesel it really does take to fill up a jumbo jet. Chances are the friend you asked second will come up with a higher estimate than the friend you asked first. And the reason for this has to do with anchoring. What happens is they use the numbers that you put in their heads, 132 versus 132,000, as frames of reference. And they become anchoring points on which they base their future estimates. And by the way, in case you're wondering, it takes around 58,118 gallons to fill up a jumbo jet. So in personal injury loss settlement conferences, an insurer will sometimes give a lowball first counteroffer, which becomes a frame of reference the anchoring point on which will influence our client's future judgments. Our clients emotionally react to such a lowball first offer, which can be emotionally traumatic, especially if they had higher expectations. What makes it worse is that we tend to gravitate towards the focus point that has the most psychological significance for us, which in this case is the emotional traumatic reaction associated with the lowball first counter offer that could impact their future. So to mitigate this, I communicate to my clients the influential power of the use of anchoring and label how it will make them feel before the settlement conference. So when it happens, they'll be mentally prepared and not be as emotionally shocked and anchored by it. At the trial stage, I just want to briefly say, just be careful not to overpromise a massive victory at the trial, especially if it's a jury trial, because as you know, they can be very unpredictable. Again, our clients like when they're honest about your evaluation of the case, mention the strengths and weaknesses of your case going into the trial. Again, it's better to underpromise as opposed to over-deliver. When our clients testify at a trial as witnesses, it is them, not us, who give the oral evidence from which either a judge or jury will make a decision. So again, using empathy, I know that since being a witness for our clients is largely unfamiliar and unknown, they are very uncomfortable and oftentimes petrified. They begin to worry about whether or not they remember important facts, which might affect their credibility in the eyes of the trier of fact. So I spend time early on preparing them to give evidence as part of the trial preparation, as well as demystifying the trial process. I do role playing to prepare them for being cross-examined by opposing counsel and being examined in chief by myself. At the end of the client's journey, don't forget the final statement of account is also a valuable communication tool. Clearly illustrate disbursements you've written off so your clients see the full extent of the value provided, even if they weren't charged for it. Make sure you clearly outline what you're charging for, both the minor and especially the major disbursements, and make sure it's detailed enough for your clients to understand what they're being billed for. At the end, real quickly, clearly end the legal representation of a closing letter. And don't be afraid to ask for feedback from your clients based on the time they spent with you. It's important to learn how to continue to improve your client's experience of working with your law firm. If your clients had a great overall experience that was topped off with a very good settlement or verdict following a trial, then it's a perfect time to ask your clients when their emotions are high to communicate to you how they felt about the experience with a positive Google review. Lastly, if your clients had a great experience, stay in touch with them. Remain in their minds. For example, I use automation to send them an email on their birthdays. You advocated for them during the retainer, and now after the retainer is closed, they can advocate for you and your law firm when you're not there and vouch for you and refer new clients to you. Thank you.
Wow, thank you, Andrew, so much for that. Really quickly, before we get into Q&A, we're just going to throw up a couple of polls. So the first poll that's going to come up is for existing Clio users, Clio customers. So when it comes up, if you want to talk about any of our products, just feel free to respond there. And then we will have someone reach out to you directly and they can talk to you a little bit more about each of the products. So we'll give that just another couple of seconds here. And then we will jump into Q&A just after this. So lots of questions for you in the chat and in the Q&A, Andrew. A lot of people are really excited about some of the content. Okay, let's go ahead and throw up the other poll. This is for non-Clio customers. If you want to speak to one of our reps about your firm, your situation, and learn a little bit more about the products, just feel free to respond here, and then we will have someone reach out. Okay, I'm going to keep that up for just a little bit longer, but let's go ahead and move into Q&A if you want to go to the next slide, Andrew. Okay, so lots of questions for you. The first one up is specifically, how are you using Clio Grow automation to make a smoother process?
Yeah, so what I like about Clio Grow is the pipeline that you can create, right? And how you can set different stages that have to be completed to monitor the progress that you're making. With the Kanban type boards, it gives you a visual of the progress you're making so you can see how far that you have gone. I like that I can set deadlines to complete these various tasks. And at the top of the screen, you actually have a progress bar which starts to fill up as you complete every single task. So you can see the progress that you're making. I like the email campaign templates that I create as well, which takes care of a lot of emails that just go out automatically when a particular task is done. So I don't have to do it. And then again, it just, all of those things just help me to expedite the process. With the task templates, or the checklist, the task checklist I create, actually, I like that. It's kind of analogous to like a pilot. Before a pilot takes off in his plane, he has a series of things that he has to go through before he leaves, just to ensure he's safe. I kind of view it the same way. It just ensures that I cover all the bases, and I do so in a very efficient manner.
Great, thank you for that. So there were a lot of questions around kind of which products you were using here in order to create those email templates. And so one question was, did you say that the software is called Pipeline to update clients in each stage of the case? So for this question, Andrew's been talking about Clio Grow, but maybe you could clarify, Andrew, kind of the email templates in Clio Grow and the Pipeline versus Matter Stages in Clio Manage.
Yeah, so in Clio Manage, I use Matter Stages, and it basically enables you to define or customly design or create your own titles for the different stages you go through in the predictable litigation process. So if you look at my Clio Manage, you would see that I've identified 10 different stages. And again, it's like a Kanban style setup. So when I open up the matter to begin with, there's a little, my client's matter is at the first stage. And within that first stage, I identify different tasks that have to be completed that's only associated with that first stage. And I give myself timelines and deadlines. And then I also have a series of documents that I only use at that particular stage so I can create them easily. So in Clio Manage, I'm using it to visually monitor my progress, bringing my client from the beginning when he signs the retainer all the way to either a settlement conference or the trial, and to make sure I'm going through all those stages of no delay. And I'm doing everything that needs to be done in each respective stage to keep myself safe. And that's similar to Clio Grow, but obviously it's for a different purpose. There's also a Kanban type setup where you have different matter statuses that you can create or define on your own during the intake process. And it functions the same way. It gives me a bird's eye view of the progress that I'm making, facilitating that prospective client, becoming a prospective client to becoming ultimately a retained client. There's different steps in that process. I'm able to define those steps, set deadlines to complete those steps, and make sure I'm moving him in the right direction without any delay.
Great, thank you for that explanation. And then if you are not a Clio customer, some of that was going over your head, and we will cover both Clio Grow and Clio Manage in our session later today, so make sure you join then. Last but not least, I know we're at time here, but lots of questions about people wanting to see your templates. Is there any way that they can get in touch with you to see some of those email templates that you talked about a little bit today?
Yeah, absolutely. I can certainly give out some of those templates. With regards to my templates, like I said, each stage of the litigation process is very predictable. I think in one of my earlier slides, I identified the 10 ones that I use, and the goal in each of the stages are the same. So it's relatively easy to construct a letter outlining all of those goals, because you're trying to accomplish the same thing for each client. And like I said in my presentation, you just have to alter it a little bit or add some particular facts that are unique to your particular client's case just to complete it, which doesn't take that long.
Great, thank you for that. So many questions, but that's where we're going to have to stop today. But feel free to connect with Andrew in the lobby chat. You can find his name and send him a quick message. Thank you, Andrew, so much. This was such an impactful session. So many comments about how relatable all of the content was, and little nuggets of information that a lot of us took away. So thank you again for being here today and for sharing with us.
Thank you so much for having me. It was an absolute pleasure. You can contact me anytime via email. I'll try to get back to you as soon as I can.
Great. Thank you, everyone. See you in the next session.